The Supreme Board of Judges and Prosecutors, HSYK, is sanctioning arbitrary suspensions, dismissals, and investigations of members of the judiciary, such as the decision to suspend 31 judges and 18 prosecutors on suspicion of allowing illegal wiretapping in the Iran-backed terrorist organization Tawhid Salam case, according to a number of legal experts and politicians. The criticism came after the HSYK suspended 49 judges and prosecutors involved in the Tawhid Salam case. Earlier in the week, the HSYK had granted permission for an investigation into 32 judges and 22 prosecutors who led probes into Tawhid Salam, also known as the Jerusalem Army. 49 members of the judiciary were suspended on the grounds that they would damage the influence and reputation of the judicial body if they continued their duties. Only judges Mahmut and Mustafa Kemal Özçelik of the second chamber of the HSYK were opposed to the ruling. The move prompted speculation that the government is targeting certain judges and prosecutors due to their involvement in specific cases. Of the 54 members of the judiciary initially investigated, the HSYK decided not to suspend 4 prosecutors and a judge. The suspended judges and prosecutors could be barred from the legal profession if found guilty. The investigation into Tawhid Salam was launched on April 8, 2011, but was dropped in July 2014 by the Istanbul Chief Prosecutor's Office. The move was widely seen as an attempt to cover up a highly sensitive probe that had implicated senior officials in the Justice and Development Party, AK Party, government. The decision to allow the investigation into the judges and prosecutors is seen by many commentators as retribution by the AK Party government against those involved in uncovering one of the largest terrorist and espionage rings in the history of Turkey. Tawhid Salam has been linked to a string of unsolved murders in Turkey during the 1990s. Despite the fact that those responsible for the deaths of many well-known figures, such as journalist Mahmut and academics Ahmet Tanerklal and Baray Özçelik, have never been caught, the Tawhid Salam investigation promised to shed light on some of Turkey's most high-profile assassinations. HSYK second chamber member, suspensions go against Ekthar. Judge Sen from the second chamber of the HSYK has said the suspension of judges and prosecutors at the beginning of an investigation without the defendants being allowed to submit their testimonies goes against precedents set by the European Court of Human Rights, Ekthar. Writing on his Twitter account on Tuesday evening, Sen said the HSYK dismissed 17 judges between 2004 and 2014. These judgments were always passed after a trial had been convened regarding the judge in question. Sen then went on to state that the second chamber has suspended 61 judges and prosecutors in the last 9 months alone. 5 members of the judiciary have also been dismissed and 6 judges and prosecutors have been imprisoned during the last 9 months, wrote Sen. Stating that the majority of the suspensions have concerned the rulings of the judges, Sen said, neither the HSYK, an administrative body, nor the inspectors on duty on its behalf have the right to determine the correctness of a judicial ruling. He also underlined that the investigations should be in line with the principle of judges' tenure and Article 6 of the European Convention on Human Rights, ACHR, which deals with the right to a fair trial. HSYK exempts judge with 276 signatures, while suspending judge with 1. Turkish media have reported that the HSYK added 8 judges who had only signed 1 ruling pertaining to wiretapping permissions in the Tawhid Salam case to the list of judges to be suspended, even though judges who had signed off on over 270, 115 and 33 different decisions, respectively, in the case have been exempt from even being investigated, let alone suspended. The initial inspection was into 63 members of the judiciary, but 9 of the judges and prosecutors were not added to the list of those to be investigated, and only 49 were eventually suspended. These irregularities have prompted speculation that the list was actually tailor-made to include only judges and prosecutors the government wants to discharge from duty. Prosecutors Mustafa Avolu, Abdullah Mirza Koskan, Razim Ikaltun, Muratnan and Judge Yakup Kaya were taken off the list of 54 individuals to be investigated. Furthermore, Judge Bekir Altun, a penal judge of peace who is known to have signed off on over 150 documents pertaining to the Tawhid Salam case, was one of the 63 included in the initial inspection but failed to make the 54-name list. Judge suspended over Tawhid Salam case slams HSYK. Judge Kazım Kayalı, who is currently presiding over the case of the Kurdistan Communities Union, KCK, wrote on his Twitter account that if a judge with 150 signatures is accepted while a judge with one signature is suspended, this proves that the entire investigation is politically motivated. Judge Mahmut Karababa, who presided over the Özçelik and Balyozcu cases, wrote on Twitter that he was honored to receive the same punishment as his colleagues. "I just want to ask this, what is the HSYK avenging? Who is it doing this for?" said Karababa, adding, "Those who chose to stay independent while a compliant judiciary was being set up of course knew they were going to pay a price, but you will not be able to bow our heads." Özçelik is a terrorist organization accused of working to topple the democratically elected government in Turkey. Its existence was discovered when the police found a number of hand grenades in a shanty house in Stanbul's Umraniye in 2007. The suspects, who included members of the military, businessmen and journalists, appeared before a court for the first time in 2008 in what many described as the trial of the century. Former AK party minister, HSYK originally formed to protect judges, prosecutors. Ertuğrul Günay, who was Minister of Culture and Tourism under the AK party and a deputy of the party for 6 years, on Wednesday expressed his belief that the HSYK has turned into a politically partisan body. Stating that this decision infringes on the independence of the judiciary and the tenure of judges, Günay said the real reason behind the formation of the HSYK under the Constitution of 1961 was to protect judges and prosecutors from political pressure, but that the body has recently seemed to have the opposite intention. He told the Sahan news agency on Wednesday that the HSYK is imposing sanctions on judges and prosecutors at the behest of the ruling party. The image of a government straying from the rule of law is very serious because governments are only legitimate when they are bound by the rule of law. Lawyer, HSYK decision is reply to Constitutional Court's prep school ruling. Lawyer Engin Sinman told today's Zaman on Wednesday that the decision by the HSYK had obvious political motives and that it is illegal to suspend members of the judiciary before an investigation has started. The judiciary is openly being utilized by the ruling party. After the Constitutional Court decision on prep schools, the HSYK, which is under the government's control, is replying in its own way, he said. In a landmark case, a highly controversial law that sought to close down privately owned prep schools, which help students prepare for high school and university entrance exams, was annulled by the Constitutional Court on Wednesday. The ruling, which was widely seen as a rebuke to the government after it campaigned strongly to close down prep schools, was handed down by the Constitutional Court with a 12-5 majority vote. The court said the law represented a violation of the Constitution regarding the right to education and freedom of labor. Former Justice Minister, government pressure product of parallel paranoia. Hikmet Sami Turk, who served as Justice Minister from 1999 to 2002, spoke to today's Zaman on Wednesday to say that the ruling party's behavior was due to its paranoia concerning the parallel structure, even though the government is unable to offer any evidence regarding its claims. The term parallel structure was invented by President Recep Tayyip Erdogan and his associates within the AK party to refer to the Hizmet movement, a civil society initiative inspired by Turkish Islamic scholar Fethullah Gulen. Erdogan alleges that the group tried to pull off a coup against his government via 2 major corruption probes that went public in December 2013, incriminating people in his inner circle and members of his family. Erdogan openly declared last year that he would do whatever it takes to eliminate the parallel structure, even if this requires a witch hunt. Alleging that judges have abused their powers is no small claim. Judges cannot be tried due to their decisions. The HSYK officials are claiming there has been illegal wiretapping. However, the judges only issued wiretapping permissions to obtain evidence for cases that were brought before them, Turk said. It wasn't the judges or the prosecutors who did the wiretapping, Turk added. We have never witnessed such high numbers of judges and prosecutors being suspended in the history of the Turkish Republic. They should have waited until the result of the investigation before ordering suspensions. Former Supreme Court of Appeals head, it's as if Turkey is in a state of emergency. Ali Alkan, the former president of the Supreme Court of Appeals, has said the independence of the judiciary has been eradicated in Turkey, and likened the country's condition to one of a state of emergency. Like Turk, Alkan underlined that no evidence has been found of a parallel state or that the Hizmet movement has ever engaged in any sort of illegal activity. Speaking to the T24 online news portal recently, Alkan said the executive branch of government was very noticeable in the judiciary and that it was openly interfering in its workings. I don't find it right that judges are tried due to their judicial decisions. If we are to be ruled by democracy, there shouldn't be structural changes to the independence of the judiciary or to the tenure of judges because these are the guarantees of a fair trial, said Alkan. Pointing out that the independence of the judiciary is being violated on every level in Turkey, Alkan said it is not possible to find solutions to other problems without first establishing the independence of the judiciary and tenure for judges. Council of State once ruled to reinstate prosecutor wrongfully dismissed by HSYK. Turkish media have reported that in 2014, the Council of State ruled against an HSYK decision to dismiss a prosecutor due to a failure by the HSYK to take the defendant's defense statement. In a landmark ruling handed down by the 12th Chamber of the Council of State in July 2014, it states that any dismissal was an important decision and could not be given without first hearing the defense statement of the defendant. This ruling can be applied to all forms of administrative punishments, such as dismissals and suspensions. The case began when the Second Chamber of the HSYK twice ruled to transfer public prosecutor Mahmut Bora Akisai without first hearing his defense statement. The Chamber then ruled to dismiss Akisai in January 2013. However, the Council of State overturned the decision due to the Chamber's failure to take a defense statement.